Greetings and salutations. This is Big J. I want you to check the links below that will provide the contents of what I'm talking about. Project 2025 is alive and well, and it seems that the barbarians no longer wear loincloth in skins and fur of wild game, but wear tailored suits and ties and business attire, masquerading in the halls of power. This comes from the Associated Press, and what we wouldn't see in civil society is the eroding of civil society and equal rights. West Virginia, the Senate of West Virginia passed bill that would remove marital exception for sexual assault, sexual abuse. This is by Leah Willingham of today, 7 hours ago. Charleston, West Virginia. Married people in West Virginia could be charged with certain sexual assault acts against their spouses for the first time under a controversial bill passed Monday by West Virginia's Republican-dominated Senate. The bill, sponsored by former prosecuting attorney Republican Ryan Weld of Brooke County, would remove marriage as a defense to first and third degree sexual assault. Now heads to the House for consideration. The marital exception exists or has existed in code for quite some time, well said, and I think it's time to correct an injustice. Weld explained that there are two crimes of sexual violence outlined in the state code: preventative, excuse me, I'm sorry, something was in the back. Penetrative rape, and secondly, forcible touching of a person's sexual organs, breasts, buttocks, anus of another person. For the latter offense, the marital exception shields a person from conviction if the crime is perpetrated against their spouse, even if the couple is legally separated. An individual accused of such sexual assault could not be charged. Until 1976, a married person could not be charged with penetratively raping their spouse. That law was changed at the urging of the former Republican Senator Judith Hertron, then the only woman in the legislature. Will honored Hedra on the floor before the bill passed 22-9, with 3 senators abstaining or not voting. This is carrying out on what I believe to be an unfinished job that she wasn't able to get done before she unfortunately passed away in 1980, Well said. The passage comes from some lawmakers expressed hesitation about it at a tense Senate Judicial Committee meeting last week. Republican Senator Patricia Rucker of Jefferson County, who abstained from voting because she was out sick Monday, said she wanted to support the legislation but worried about the people trying to take advantage of the statute with false accusations. If there was more protections to make certain that there wouldn't be abused by the people who are just trying to hurt the other person, it would be. I think a very easy vote. She said, I, for myself, am concerned about the weaponization, unfortunately. Sorry, that was an ambulance going by, but she proposed an amendment that would have added language to the bill stating that implied consent exists between unmarried partners, except in cases where one partner has an explicit and overtly redrawn consent. The change would also have added a provision saying consent can't be attained when a person deliberately attached misrepresent their true identity or biological sex to the victim, or knowingly and potentially expose the other to sexual transmitted diseases without informing the victim in advance. The amendment was narrowly defeated in an 8-8 vote. Speaking in opposition, Democrat Senator Mike Wolof of Cabell County said each spouse has responsibilities to fulfill in a marriage, but forcible sex is not one of them, and forcible sexual touching is not one of them. I think it goes against the concept that a woman can have no say, and that no means no, and that's it. If you cross that line, it's not appropriate. Well, who also voted no, said he was concerned about the implied consent language, which he explained goes back to the belief at the time of English common law that a wife is cattle of her husband, a possession given to her father to the husband. I would hope that we have progressed beyond that point. Well said. Adding that go to the back of the implied consent standard would be a step in the absolute wrong direction. A later withdrawal amendment by Republican Senator Mike Axinger of Wood County would require that the sexual abuse would be witnessed by two people outside the marriage for charges to be brought. He cited an Old Testament passage in the Bible which states that a man should be put to death with the testimony of 2 to 3 witnesses, but not on the testimony of just one witness. God's eyes, God law said in Deuteronomy 2 or more witnesses, he said. It seems only just and fair that it should be somebody else who saw what happened. Axinger withdrew the amendment after Well objected. You know who didn't make second-class citizens out of wives? Well said, adding, we are essentially saying that through this amendment, your word doesn't count. Your word is not good enough in order to convict someone of sexually abusing you. During the meeting at the Mongolia, I hope I pronounced that name right, County Prosecuting Attorney Gabriella Mukana Muchkata, said that the state Supreme Court has upheld that a jury can convict on an uncorroborated testimony of a victim if they considered the testimony credible. These cases are commonly unreported, she says, and that marital exemption just creates another hurdle for victims. I just can't understand why within a marriage that should be any other different than it is, let's say, in a relationship without marriage, what we trust prosecutors to do on a daily basis on any other sex crime, she said. This is my commentary on this. Welcome to fascism America, ladies and gentlemen. Welcome to they're trying to take away your rights. Welcome to they trying to take away your vote, your rights, and your liberty. My name is BIGJXXX, and welcome to fascism in 2024.